Okay, so good afternoon, everyone. Welcome to the virtual DMZ, and thank you all for joining us on a webinar series hosted by the DMZ in collaboration with its corporate partners. This webinar is presented by one of DMZ's professionals in residence, or PIR for short. The PIR program brings industry experts in-house to the DMZ through unique collaborations. Through the PIR program, current and alumni DMZ founders have access to pro bono office hours with industry experts at DMZ exclusive discounted fees for engagement as well. So today's webinar is made open to public participants, and this is to foster a spirit of support during this pandemic as entrepreneurs far and wide share similar experiences dealing with employment and contract law. Throughout the webinar, you will have a chance to ask questions to the speakers, and at the end, I will share my contact information if you'd like to have a conversation offline. Our speakers for this webinar are from Goodmans LLP, the founding legal partner of the PIR program since 2017. As one of Canada's premier transaction law firms, Goodmans has been providing strategic advice to businesses during COVID-19. With expertise spanning from business law to innovation, the Goodmans team has joined the DMZ in sharing their expertise with our community. Please join me in welcoming the team. Before I hand it off to the Goodmans team, let me introduce myself. I'm Sweeney D'Souza, the Partner Success Lead at the DMZ and your moderator for today's webinar. I also have with me Jose Bonicelli, Space and Tech Assistant at the DMZ, who will help facilitate the webinar. Here are a few housekeeping items for today. You will get a chance to meet your speakers as each presenter will turn on their audio and video when they're speaking, and this is to make the webinar as engaging as possible. Please use the Q&A feature of Zoom to ask your questions, not the chat feature. Please feel free to ask a question as our speakers are presenting. However, they will not answer the questions in real time, but we will address them in the Q&A session that follows. This webinar is being recorded. The recording will be made available after the webinar on the DMZ's free virtual workshop series page. At the end of the webinar, an anonymous survey will be emailed to each attendee. So please take a minute to let us know how we did today. So our webinar will have 3 parts. Part 1, employment law in the wake of COVID-19. Contract law in the wake of COVID-19, and finally we'll end with a Q&A session with the Goodmans team. First up to address our participants today is Alan Goodman, lawyer in the business law group and also the co-leader for the technology group at Goodmans. So I'll hand it off to Alan and he will help us get started.
Thanks, Sweeney. Just welcome everybody and hope everybody's staying safe. First of all, thanks to the DMZ for this opportunity to share some of our thoughts with our community. We feel very close to the DMZ community, having been there for so long, and can appreciate how disruptive this must be to the businesses, to the program itself. And I know the DMZ has done an incredible job in keeping things moving, and we're glad to be able to participate in an event like this to impart what we're seeing in this very unusual time. The topic when we originally spoke about doing a webinar for the DMZ community about a few months ago was employment law and contract law in the context of startups, which was all well and good. And then, as we all know, mid-March, the world changed, and what became relevant now for those 2 topics is how they are impacted vis-a-vis what's going on around us and the impact of COVID-19. As a law firm, Goodmans, I would say by about March 12th or 13th, had to move into high gear and as with everybody else in the world, shift gears and move off-site and create our own environment, which was obviously very unique to us, and we were able to do that. But at the same time, we've had to deal with clients in crisis across the board, whether it be small businesses, medium-sized businesses, investors, large corporations. Everybody's been dealing with very important issues in the context of trying to get along in this new world. In particular, as a firm, we meet twice a week to discuss COVID-related issues as they impact our clients and our community. And so what we thought would be helpful today is to impart what we've been learning in the context of employment law and contract law in particular, and not only just give you a generic overview, but try and bring to you what is relevant in the context of emerging and small businesses like yourselves. There's a lot of material here in an hour, and particularly when we're only speaking on each topic for about 15 minutes. So we are available beyond the context of this webinar to address questions. You should feel free. We don't get to them today, that we will be happy to address those after the webinar, and Sweeney will give you all the contact information on how to reach us. We are continuing to hold our meetings Wednesdays, our office hours 12 to 5. Those are being held by Google Hangouts. So some companies have been participating in that, but for those of you that haven't, please partake in that. We're available, we're ready, willing, and able with the same program we've always had when we have our office hours. So if you have questions that arise outside of these two topics, please don't hesitate to reach out on that as well. So as I say, this is dense. We'll do the best we can. I'm going to introduce our two speakers that are going to talk on the topics, and then all three of us will address your questions at the end. My colleague, Luke Bell, and Luke and Tom have been very instrumental in keeping the firm up to date on what's happening vis-a-vis government programs, changes in legislation as they've been occurring, and events generally in relation to these topics. And that's why I've asked them to speak on these, and then all of us will address your questions. Luke is an associate who does a lot of work in our employment area and is spending a lot of time on the firm's pronouncements on all the developments as they've occurred. And as Luke will get into, this is happening in real time. So what you may hear as a government program today, we get the details tomorrow, we get more details the next day, we get input from the CBCA and other entities that help them refine that. So this is really a moving target, but we'll tell you where we're at today and where we see it going. And Tom Spelt is a corporate associate in our group who has been working with us, keeping us updated on matters such as, in this case, the impact on contracts. We've been getting questions from everyone from suppliers to purchasers to M&A transactions to financings. What's the impact? How do we interpret certain provisions? So we've highlighted a couple of things that might be relevant in your circumstances. We appreciate we're not going to cover everything of specific detail for you, but you certainly use the Q&A session, as I said, to address something that might be more helpful for you. And obviously offline, we can do something quite specific for you. So with that, I'm going to turn it over to Luke, who's going to get us started on the employment side of this. Thanks.
Okay, thanks for the introduction, Alan. So today I'll be addressing two aspects of employment law in the wake of COVID-19. So the first being employer responses. So these are measures employers have taken in response to COVID-19 and the resulting economic downturn. And the second being government responses. So these are measures introduced by the Canadian federal government to assist employers and employees facing economic hardship as a result of COVID-19. So one important thing to note, as Alan mentioned at the outset, is that changes are occurring quickly and government responses and programs are changing daily. So employers are encouraged to continually monitor government announcements for measures or programs that may impact their business and their employees. So turning to our first part of this presentation, employer responses. Employers have faced a number of challenges in the wake of COVID-19, which in Ontario have varied depending on whether the employer operates an essential workplace or non-essential workplace, as determined by provincial government's emergency order, which is fluid and subject to change. Employers who operate essential workplaces that require employees to be physically present on site have faced the challenge of protecting workers from the transmission of COVID-19 in the workplace, in line with their duty to provide a safe workplace in accordance with occupational health and safety laws. We have seen these employers implement new systems to keep employees safe, including mandatory temperature screening, physical distancing protocols, and providing employees with personal protective equipment. These employers have been confronted with legal issues, including the legality of temperature screening in light of their human rights and privacy obligations owed to their employees, and dealing with employers who have refused to work over concerns of COVID-19. Conversely, employers who have been unable to operate as a result of the provincial government's emergency order, or employers who have experienced significant declines in revenue as a result of the economic downturn, including those who are able to work virtually, are facing the challenge of reducing business expenses, including payroll obligations, just in order to survive. We have seen many employers implement temporary layoffs, while some have opted for other approaches, including wage reduction agreements, and in some cases, employers have been forced to permanently terminate their employees. Employers looking to reduce their payroll obligations through these measures must assess the associated risk of doing so, and should also consider whether they're able to avoid layoffs and terminations by accessing government assistance programs that we'll discuss in more detail later on. For employees considering or who have already taken steps to reduce their payroll obligations, they should consider the following in respect of layoffs: the maximum duration of temporary layoff permitted by applicable employment standards legislation, whether layoffs are permitted by the employee's contract of employment, whether they can access government assistance programs in order to avoid layoffs or recall employees who are on a layoff, and where layoffs are not contemplated in an employee's contract of employment, or where the employee does not have a contract of employment, the risk of the employee bringing a claim for a constructive dismissal. Now, in respect of employers considering work reductions, employers should consider whether employees have agreed to a work reduction, the risk that the work reduction will constitute, and the risk that the work reduction will constitute a constructive dismissal. And finally, for employers considering terminations, the employer should consider the employee's termination entitlements, and they should also ensure that terminations are conducted in a non-discriminatory manner. Now, I've had a number of questions come up over the past month in relation to these issues, and I thought I'd share them with you. So the first being, can I lay off my employees? The short answer is yes, you can temporarily lay off employees. In an ideal situation, employers will have a properly drafted employment agreement or manual which explicitly allows the employer to lay off employees. In the absence of such, or in the absence of a written employment agreement, in some circumstances, a layoff may constitute a constructive dismissal, and the employee may be able to claim his or her termination entitlements. Now, whether or not there has been a constructive dismissal will depend on the facts of each case. There are a number of factors, especially in light of COVID-19, which may mitigate the risks and potential damages associated with a constructive dismissal claim. The second question that I've frequently got from clients is, do I need to pay any remuneration to employees on a temporary layoff? So do I need to pay any wages of the sort? So no, there is no requirement to pay employees any remuneration during a layoff if the layoff is less than 13 weeks in a 20-week period. However, if an employer continues to pay some form of specific remuneration as set out in the Employment Standards Act, including contribution to benefit plans while the employee is on a layoff, the layoff can be up to 35 weeks in a 52-week period. And the last question that I have received frequently is, how long can I lay off my employees? So this will vary by province, but in Ontario, it's 13 weeks in a 20-week period, or 35 weeks in a 52-week period, as I mentioned earlier, if the employer continues to provide some form of specific remuneration to employees during the layoff. And so once the layoff exceeds the statutory minimum, the employee's employment will be deemed to be terminated, and the employee will be entitled to their respective severance entitlements. So that's just a very quick overview of some of the employer responses that we've seen. And if anyone has any specific questions to any of the issues that I discussed there, please feel free to submit them to the Q&A. But I'll move on to the second part of this webinar presentation, which is the government responses. So we're going to look at the measures the federal government has implemented to assist employers in meeting their payroll obligations to employees. So you'll see there I've listed some of the programs that have been made available, but I've also included a link down the bottom to get a more fulsome list. Over the next slide, I've also included a timeline, and that is to illustrate So just, I think over the slide, if we can, to the timeline. So I've included a timeline to illustrate how government measures to stop the spread of COVID-19, which have resulted in an instant decline in economic activity, were met with government responses to support employer and employees experiencing economic hardship. Now, in many instances, as you see from the timeline, there is a gap between the program commencement and the government restrictions. And for this reason, most of the support programs that the government has implemented have a retroactive effective date for sometime in mid-March, when those some of those more severe restrictions came into place. Now, I'd like to speak about, over the slide, the Canada Emergency Wage Subsidy. Now, this is a program where applications opened on Monday, and under the program, eligible employers may be entitled to claim for each eligible employee a wage subsidy, which is equal to 75% of the amount of wages paid to that eligible employee, up to a maximum benefit of $847 per week. And the second component of this wage subsidy is for payroll contributions paid for each eligible employee for things such as EI and CPP premiums. Eligible employers will be able to get a 100% refund on these contributions. So they will still need to make these contributions to employees, but they'll be able to get the refund if they're eligible through this program. So I've also noted on the slide kind of the three-part eligibility test. I'm going to simplify it as much as possible. And obviously there's more detail. So the first part of it is you need to be an eligible employer. This has a fairly broad definition and captures most businesses, including corporations, non-profit organizations, registered charities, and partnerships. A second requirement is that the employer needs to have a CRA payroll account on March 15, 2020. So they need to have had that in place, otherwise they won't be eligible. And the third part, which would ultimately determine eligibility for most businesses, is they need to have had an eligible revenue reduction. So employers will be eligible to receive the wage subsidy for eligible employees if they can demonstrate a revenue reduction of 15% for the month of March 2020 and 30% for the month of April and May 2020, compared to the corresponding month of 2019, or the average of revenue for the months of January and February 2020. So the reason for these two comparative reference period is because not all businesses will have had revenue in March, April, and May of 2019, and some businesses weren't even existent at those times. So eligible employers who've had that revenue reduction will be able to claim the subsidy for wages paid to eligible employees in respect of 3 claim periods. The first period is March 15 to April 11. The second period is April 12 to May 9, 2020. And the third period is May 10 to June 6, 2020. So employers will need to meet the eligibility for each month in order to maintain, in order to claim the subsidy. Now, if an employer selects the year-over-year reference period, or if they select the average of revenue for January and February, that will need to be the reference period that they use for each claim period. Now, if employers are not currently generating any revenue, then they will not be eligible for the Canadian Emergency Wage Subsidy, but they may be eligible for other government assistance programs, which we will discuss later on. And that includes the 10% temporary wage subsidy. So moving on to some of the frequently asked questions that I've had in my practice. First being, are employers obligated to top up salaries to 100%? So the short answer is no, but there is an expectation that employers will top up if they're able to do so. So it's very much a best efforts basis to top up wages. The next question I have there is, who is an eligible employee? So an individual employed by the employer in Canada during the claim period, which we spoke about earlier. And an employee will not be an eligible employee if there is a period of 14 or more consecutive days in a claim period in which that employee did not receive any form of remuneration. So if the employee did not receive any wages for 14 or more days in the month of the first claim period, then they won't be eligible for the subsidy in that first month. The next point, and I also did want to mention that contractors are not eligible employees, as I know some of you will be working with contractors, so that you won't be able to claim the subsidy in respect of any fees that you pay to them. However, the contractor may be able to, in their personal capacity, eligible to apply for the Canada Emergency Response Benefit. So the next question that I wanted to address was, how do I apply? So you can apply for the subsidy through your CRA My Business account. And as I mentioned a little earlier, applications open on Monday, and I think there was something like 30,000 applications. So already a lot of businesses are already taking advantage of this subsidy. So the next point I'll bring up is what happens if I receive the subsidy when I'm not eligible. So if you haven't experienced that revenue reduction, or if say you're not generating any revenue, so you're not eligible in that point, the government has said that those people will be required to repay those amounts, and there may be penalties in place in the case of fraudulent claims, including fines, or in even serious cases, imprisonment. And finally, I'm approaching the end of my time, but I did want to quickly touch on this, is what happens if I'm not eligible for the wage subsidy. So as I briefly mentioned, there's a number of other programs in place, and unfortunately I'm not going to have the time to go into these in detail. The first being the 10% temporary wage subsidy, which eligible small employers will be able to claim a 10% subsidy up to $1,375 per employee. The other programs that would be worth exploring is the Business Credit Availability Program, which includes guarantee programs and a forgivable loan. And so at this point, I think it's going to be time to hand over to Tom, but if anyone does have any further questions about those other programs, please feel free to raise them in the Q&A. So with that, I'm going to hand it over to Tom.
Thanks, Luke. So we're now going to discuss the implications of COVID-19 for contract law. And obviously, we've been hearing from our clients that COVID-19 and the government response to it have thrown up a number of challenges. We've seen disrupted supply lines, reduced sales, reduced cash flow, and all of that can make it more difficult or even impossible for businesses to fulfill their contractual obligations. So in light of that, I'd like to touch on 3 topics today. Number 1, we're going to discuss how businesses can approach existing contracts and contractual obligations, and also think about how businesses might renegotiate or draft future contracts. Number 2, we're going to think about insurance in light of COVID-19. Number 3, I'll just bring to your attention some further government programs designed to mitigate the impact of COVID-19 on small businesses. So obviously, given our time constraints, this will be more of an introduction to these topics. And if you have a specific question, please raise it for the Q&A, or feel free to approach any of us after the webinar. So if we move on to the next slide, we'll get into our first topic, which is looking at what options are available to businesses which are struggling to perform their existing contractual obligations due to COVID-19. And broadly speaking, there are 3 approaches out there. A business can try to temporarily suspend its performance under a contract. A business might try to permanently terminate its performance under a contract, or a business could try and amend or renegotiate the contract in question. And there are a few different ways a business could go about doing this. We'll be talking about force majeure clauses today, as well as the defenses of impossibility and frustration. We'll quickly look at termination rights and renegotiation as well. So moving on to slide 3 and force majeure. You might have heard of force majeure clauses before. They're certainly getting a lot of focus now, as they're perhaps the most common way in which a party can go about getting relief from contractual obligations due to COVID-19. But not all contracts have force majeure clauses, and not all force majeure clauses operate the same way. So generally speaking, in a contract, a force majeure clause is going to determine which party bears the risk of non-performance or delayed performance due to some force majeure event. So a force majeure event is something that's unforeseen, that's beyond the control of the contracting parties, and that prevents a contracting party from fulfilling its contractual obligations. Common examples are things like natural disasters. You might see earthquakes or floods mentioned, riots or strikes. And for the purpose of many force majeure clauses, COVID-19 will qualify as a force majeure event. So this is one avenue of recourse you can use to get relief from your obligations. But force majeure clauses are very, very important because the principle of force majeure isn't available in common law. And that simply just means that without a valid and applicable force majeure clause in your contract, even if you've been impacted by something like COVID-19 or a force majeure event, you might still have to perform your contractual obligations. So this can obviously have serious financial consequences. So it's really important to look at force majeure clauses, make sure they're in your contract, and make sure they apply. And if we move on to slide 4, we'll get into the analysis, thinking about how you might go about doing that. So as I said before, not all force majeure clauses operate in the same way. And I'm going to take you through this 4-step analysis that you can use to determine whether or not the clause that's in your contract or the clause that you're drafting covers you for events like COVID-19, future pandemics, anything going forward in the same vein. So step 1 is assessments. And this is pretty much does what it says. You just have to assess whether or not force majeure clause in your contract covers COVID-19 or events like it. And this is going to be something you assess on a case-by-case basis. It's all going to come down to the specific wording of the clause. And there's a range of wording options out there that can do the job. Your contract might have something very specific in it, might mention COVID-19 by name. You might see a sentence along the lines of, you'll be covered for performance that is hindered or delayed by the outbreak of COVID-19. But you might also see more general language referring to pandemics or public health emergencies, quarantines, or government action. And still more general language at its broadest, the force majeure clause might say that you'll be covered for other events beyond the reasonable control of a party. So any one of those options might work for you. Everything from the very specific to the very general, all of that can operate to make sure that you're covered if you can't perform your contractual obligations due to COVID-19. But the downside of that is that if a force majeure clause doesn't contain language that seems to cover COVID-19, whether generally or specifically, you won't be able to get relief from performance. So it's important to think about that when you're reviewing your current contracts and when you're negotiating contracts going forward. And that's step 1. Read the clause, assess the language, determine whether it applies to non-performance or delayed performance caused by COVID-19. Step 2 is simpler. That's about notice. And so if you've satisfied step 1, you are convinced that you're covered, you want to look at the force majeure clause to see if there are any notice provisions within it. Many force majeure clauses require parties that have been impacted by a force majeure event to provide written notice of that to the counterparty. And that written notice often has to be given within a determined period of time. So if you give notice properly under the clause, your force majeure relief will be available. But if you fail to give notice, even if you otherwise would have had access to relief and you otherwise wouldn't have had to perform your contractual obligations, you might not be able to do so. So it's important to be aware of those notice provisions. Step 3 is causation. And this is something that's typically required in force majeure clauses. They often ask an impacted party to prove 2 things. You have to prove that it was the force majeure event itself, so in this case, COVID-19 itself, that stopped you from being able to perform or delayed your performance, as opposed to some other thing. And you also have to prove that the impact COVID-19 had on your performance was sufficient to prevent or delay it. So using COVID-19 as an example, a business hit by COVID-19 would have to show that it it was actually COVID-19 or something related to COVID-19 which caused its inability to perform. And it would also have to show that the impact of COVID-19 was serious enough to affect its performance to the extent required by the clause. And again, that comes down to the precise wording of the provision. So again, as you're drafting a contract or negotiating a contract, you have the ability to determine what standard is required. But your provision should make clear whether a delay in performance will be enough to trigger the clause, or whether performance has to be prevented entirely. And that's because if your clause doesn't make this clear, it's going to be left to the courts to interpret the clause. And that puts you in an area of uncertainty, because in the past, courts have applied a range of thresholds to this decision. Sometimes they require actual sort of physical impossibility of performance in order for force majeure clause to apply. And other times they require a lesser standard, something like just performance becomes commercially unfeasible. But if you don't have specific language addressing that in your clause, you're kind of at the mercy of the courts. So the takeaway here is that you want to consider this upfront. You want to make sure your clauses contain that kind of language. And it's something to be in mind when you're reviewing current clauses as well. So to sum up step 3, in order to take advantage of a force majeure clause, you're going to have to show that the force majeure event in question, in this case COVID-19, was beyond the control of the parties, was unexpected or reasonably unforeseeable, and actually hindered performance. And in most cases, COVID-19 will satisfy those requirements. The final step is mitigation. And this means that even if the other 3 steps are required, you can't just sit back and try and rely on a force majeure clause. You have to often show that you've taken steps to mitigate the impact of the damage done, or you've done something in good faith to reduce the effect of the impact. And that will be set out in the force majeure clause as well. So it's important to review any clauses in your existing contracts to see what steps you have to take after you've been affected in order to get the relief the clause otherwise provides. So that's the 4-step analysis, how to think about these provisions. And if we move on to slide 5, we'll talk about what happens if you actually successfully invoke a force majeure clause. So if you've satisfied all those elements, force majeure clauses generally allow you to either delay the performance of your obligations or to be excused from performance entirely. And that can obviously be very useful in a situation like the one we're dealing with now. But it's also important to think about this from the perspective of a business that's had a COVID-19 related force majeure clause invoked against it. So if one of your counterparties says, hey, I can't perform, COVID-19 happens, look at our force majeure clause, you'll want to do a few things in response. You'll want to conduct due diligence, and that's going to involve making sure the facts are what they say they are, making sure they can't perform like they said. You'll want to analyze the provision in the contract, go through that 4-step analysis we talked about above, make sure that COVID-19 is actually covered. You'll want to consider alternative resolutions. So perhaps the contract can be renegotiated. Perhaps you can just sit down and discuss this thing. You want to think about preserving your supplier relationships, your relationships to other parties. And then finally, you might think about termination rights, because some contracts, some force majeure clauses will allow you to terminate a contract if your counterparty can't perform because of force majeure for a certain amount of time. So be aware of all those options if someone says they can't perform due to COVID-19. Moving on to the next slide. We're going to look now at what happens if your contract doesn't have a force majeure clause, or if the force majeure clause doesn't apply, because there are other options available. Unfortunately, it's harder to qualify for these options. It's harder to make use of them. So your best bet is to have a force majeure clause in your contract. But if you don't, you might be able to rely on the defense of impossibility. And this is something that a court can find for in your favor. The court can say, look, performance became objectively impossible here due to some event outside of your control, and therefore you don't have to perform. Unfortunately, it's quite a high bar to rely on that. The performance has to be physically or legally impossible. The second option is the defense of frustration. And this is a very limited defense. It only applies in a narrow set of circumstances. And basically, it would involve a court saying, the purpose for which you entered this contract has been destroyed. The contract doesn't make sense anymore due to some event like COVID-19, and therefore you don't have to perform. So those options are available, but it's far less of a guarantee that you'll be able to take advantage of them. It's much safer to have a force majeure clause in your contract and try and get relief from any contractual obligations that way. It's also important, sorry, before I move on, just to think about the fact that more practical solutions might be available. If you have the ability to think about this crisis in the long term, it's important to think about amending or renegotiating contracts if that helps your partners out, just looking to preserve those relationships, communicating with your partners and thinking about alternative solutions like adjusting performance obligations and waiving penalties, things like that. So it's not all down to those three options. There might be some more reasonable solutions available as well. If we move on to the next slide, we're just going to quickly touch on insurance in light of COVID-19, because this is something that's also coming up for a lot of our clients. And it's kind of similar to force majeure clauses in that whether or not a disruption caused to your business by COVID-19 will give rise to an insured risk is going to depend on the precise terms of your policy. So again, that's a case-by-case analysis that's looking at the policy and analyzing the language used within it. But it's important to be aware that insurance providers are going to be dealing with a huge wave of claims right now. So they're going to be looking for any opportunity to deny your claim. And with that in mind, there are a few things you can do to maximize your chances of making a successful claim. You're going to want to comply as precisely as possible with the terms of the policy. And that might involve giving prompt notice. As soon as you're impacted by an event, you want to alert the insurance provider. That might involve taking certain steps to mitigate any loss or damage you suffered. And that might involve making certain ongoing disclosure to the insurance provider with respect to the actions you're taking to mitigate. So if you do all these things, you're much more likely to succeed with your claim. Providers are probably going to require strict compliance at this time. They're going to try and interpret coverage narrowly, and they're going to try and interpret exclusions broadly. So if you keep that advice in mind, you'll have a better chance of getting relief in light of your insurance policies. And then just to finish up, I'll briefly mention a couple of other government programs that are out there designed to assist small businesses at this time. We don't have time to get into all of them in detail, but you have things like the Business Credit Availability Program, which is designed to make credit available to small businesses affected by the COVID-19 crisis. We have the Canada Emergency Commercial Rent Assistance Program, and this is something that's sort of designed to make it easier for landlords to give you a break on your rent. Rent is something we're hearing about as being a particularly problematic expense for small businesses at this point. So this program is something your landlords might be able to take advantage of if they decide to defer your rent or let you not pay rent for the months of April, May, and June. I think that's what's currently being considered. These programs are evolving on an ongoing basis though. So we'll keep you updated. Goodman's is publishing resources to keep you updated as that happens. And then there's a couple other programs there which provide access to grants for research or other funds in connection with COVID-19. So for more information on these programs or for anything that I've discussed today, please feel free to contact Alan, Luke, or myself. I think now the plan is to move on to a Q&A session. And so I'll turn that back over to Sweeney and we'll take your questions.
Thank you, Alan, Luke, and Tom, for walking us all through important considerations as businesses face these unprecedented challenges. So we have received a couple of questions, and I am going to try to get all of them answered. Maybe what I can do is start with a question that came from the employment law segment, and it was a question that was, what are the implications of voluntary salary reductions? So maybe it's Luke or Alan, whoever wants to chime in on that.
Go ahead, Luke.
Okay, so with salary reductions more generally, so the risk there is that a salary reduction might constitute a constructive dismissal. So just for everyone's benefit, a constructive dismissal is essentially a fundamental change in the employment contract. And if there is no employment contract, it can also be an oral employment contract. So essentially the employment agreement in place, it's a fundamental change to it. And a constructive dismissal is a claim that an employee brings, and essentially they can claim their termination entitlements if they're able to prove that they've been constructively dismissed. So in the case of a voluntary wage reduction or hourly reduction, there's less risk of a constructive dismissal given that the employee has agreed to it. So it may be viewed as an amendment to the employment contract if it is voluntary and there's no other factors such as duress or they haven't been forced to do it.
Okay, perfect. Thank you, Luke. So there's another question here as well related to employment. Is there a 20% wage reduction without reduction in hours legal?
So I guess it's the same point of that constructive dismissal risk. If you have an agreement from the employee to work at a reduced rate for the same hours, and that constructive dismissal risk is lessened. We've certainly been encouraging many of our clients who are reducing wages to also reduce hours to mitigate any damages that may come from a constructive dismissal claim.
Okay, perfect. Thanks, Luke. Now there's one question that I'll take, which is from the contract segment. If I am a widow and the other party to the contract is a whale, and they decide to walk out on a signed contract, is there anything I can do about it? So I guess the whole question is, the other party of the contract is much more powerful, has much more means and resources, and obviously we're here talking to tech founders, right? So there's a little bit of concern there. But what?
Let me take that, Sweeney, because it's a fair question, but I think the world has changed dramatically. And the reason we raise some of these things that might seem really legal and technical is I'm dealing with about 3 or 4 matters for small companies that, first and foremost, you have to understand whether or not you have a right. So the things we're telling you to look at are important to look at. Whether or not you're going to be successful is a different story. But I can tell you in a number of cases, and this is small entities vis-a-vis large banks, there's a public relations piece to this. And large institutions do not want to be seen as crushing founders and small entrepreneurs. So step one is understand your rights. Make sure you avail yourself of reading the contracts closely. A number of these provisions that Tom talked about are buried at the end of contracts that no one even looks at when they sign the deal. You're always looking at the economic terms. These are standard, and whether or not your force majeure clause says pandemic or doesn't say pandemic, that's really important. So once you know you have a right, and whether it's you trying to make the claim of force majeure against the company or it's you a supplier telling you they can't deliver, you have to read those carefully. And then just because they're large and you're small, I don't think that you should walk away or just bend over. I think that the issue here is that there's a public relations piece of this that we've never seen before, and you will be surprised how large institutions are trying to work with and be accommodating. So I saw that question. I want people to take away here that although you might have found some of this a bit technical, I think it's very important to treat yourselves now as more on an even footing vis-a-vis those discussions, because companies are very concerned about how they're dealing with you.
Thanks, Alan. Now there's another question here related to employment, which is, can an employer temporarily lay off someone with no pay and ask them to continue working on a volunteer basis?
So I think I'd have concerns there with respect to employment standards, minimum standards. So if you're getting someone to work with no pay, that would be in violation of the Employment Standards Act, which sets a minimum wage. So that employee may be able to bring a claim with the provincial regulator to claim those wages.
So what if, I guess I'm just trying to maybe read a little more into the question then, is it, if the employee insists that they do want to help out and they don't want to just let the business owner, be by themselves, is there a way then to make it so that it'll work for both parties and there's like a volunteer type of agreement or an arrangement that would work instead?
Yeah, I think as long as it's not tied to, there's no compulsion to work, as long as it's saying like, if you want a job at the end of this, that, you'll need to work on a volunteer basis. If there is some form of agreement, the Employment Standards Act is enforced by reporting. So if the employee's actually agreeing to work on a volunteer basis, then it's quite unlikely that employee is going to report to the employment standards regulators. So I think if there is some form of agreement, that risk is significantly reduced. And if that was papered in writing in some way, just saying that, you know, there is no obligation for you to work, I can't pay you at this time. And I think one other thing to consider is whether or not the employer is able to take advantage of those government subsidies. Now, given that some programs may be able to assist that employer to pay that employee some wage.
Right. Yeah. Thanks, Luke. This is another one I am guessing maybe Tom or Alan for you. Are you able to use this CECRA for home use if you use part of your home for office use? And if so, how could you do this?
Yeah, let me just speak to CECRA because it's really become, there was a nice announcement by the federal government and then all the detail has just come out. And what we're learning is this is very much dependent on your landlord's participation in this. There's not really a lot you can do. The program requires the landlord to enter into a deferral agreement with you and some kind of arrangement with you. And the money flows through the landlord or through the mortgagee of the property if it's a bank that's a lender. So unfortunately, as much as it's been promoted as a program for tenants and really going to assist tenants, it's going to be dependent on your landlord. Now, a number of landlords will be prepared to do that because they're going to want the cash flow, but a number of them are not going to want to do it because the problem is they have to set up if they agree to take this money, they can't evict you, et cetera. And some of the concerns that landlords are going to have is, well, that's fine that you're not paying rent, but what if there's some other default or some other reason to want to move past that once this program's in place? So unfortunately, right now, it's not really that tenant friendly, but for those of you working maybe with smaller landlords or other larger landlords that are using the program, do speak to them about it, try and see if they're using it, try to push them to use it, but it really is dependent on the landlord's willingness to adopt the program. And I do see a question tied to that about whether or not you can access it by using your home or your own property, and that is not the case. It's got to be a commercial property, so you can't use it for that.
Tom, I think you wanted to add some thoughts there. Maybe you could also answer this other question that's related. Is there any other way that the tenant business can get rent assistance when a property owner does not or is not willing to get CECRA?
Well, Alan covered the point I was going to make about CECRA applying to commercial real estate instead of places like home offices. And he also might want to chime in on the other question, but I think it does go back to that public relations piece he spoke about. Other than CECRA, you might be looking at the kind of technical clauses we spoke about today, force majeure, things that might get you relief that are already within your existing contract. So it's important to look at the rights you have within those agreements.
Right. Okay, I think this is another one now related to employment, so maybe throw it back to Luke. There was just some clarification that I guess an attendee needed, that payroll has to be in place as of March 15th, meaning you can't pay late filing fees to backdate. Maybe you can just provide some more clarification.
Yeah, so that there hasn't been any particular guidance on this point. And I did see this question pop up during the course of my presentation, so there hasn't been any guidance. So I think for this person, first I'd look and see if you have had that eligible revenue reduction that we spoke about, because I think that's going to be the main driver of your eligibility. And then through your My Business account, the CRA has actually set up a hotline for questions just like this, the more technical rollout aspects of this. And I'd encourage that person, if they had that revenue reduction, to contact the CRA with that question.
Perfect. Thank you. I guess this is now, we have answered all the questions that did come in I have a question that I would like to ask maybe Alan, because we have some attendees here who might not be part of the DMZ and they are part of the larger, community. How can someone like that, I guess, engage with Goodman's at this time during COVID-19? I know, like you mentioned, a lot of things have changed from regular course of business. So is there any suggestion that you would give them?
Yeah, so first and foremost, Goodman's has published a COVID-19 update legal implications aspect to our website. So we're publishing material constantly on all topics, from access to the courts to contract law to employment law. So start there. If there's things you are interested in or you want to get some updates on, and as I say, and as Thomas said, this is moving daily. So we're publishing, many times a week on different topics. But because, notwithstanding you may not be a member of the DMZ community, I think this material is going to be made available. Our email addresses are there. By all means, feel free to reach out to any of the three of us. We're happy to address your questions. We're all available and willing to help this community, whether it's DMZ or the larger early stage startup community or business community. So please feel free to reach out to us. We're happy to address it and help you where we can, or at least direct you to resources that may be more helpful. But by all means, that's what we're here for.
Thanks, Alan. We did get a question that came in while you were speaking, so maybe we'll just get to this one before we end off. So the question, I think, is more in terms with Tom's segment. If you had a 2-year contract with a supplier and they initiate the force majeure clause, will the contract's length be suspended? If COVID-19 keeps suppliers closed for another 18 months, will that mean that only 6 months are left on the contract? Or will the 2 years start when the supplier rescinds the force majeure clause?
That's going to be determined by the specific language of the force majeure provision in the contract. If the clause is invoked and it's done so successfully, relief becomes available backdated to the date when the force majeure event happened. So that's some guidance I can give you on timing. But with respect to whether or not performance is going to be delayed and for how long, that's something that's going to be determined by reference to the terms of the contract itself.
And I would say practically, you should understand what the contract says, and it gets back to the point I made earlier, but everyone wants to do business at some point. And now maybe the supplier just doesn't want to fulfill you and wants to fulfill somebody else, but it's worthy of a discussion as to whether you want to, as Tom said, there's options here to amend, renegotiate, try and figure something out. So I think, it's 2 steps for all of this, given where we are. There's the very important technical piece of understanding your rights, but there's a very important practical piece to this, that people are trying to make things work here and they don't want to, be harmful to some businesses. So don't underestimate that. I'm telling you, we're dealing with a number of these cases where I've been surprised at the outcomes, vis-a-vis large banks, vis-a-vis large insurance companies. So treat yourself, be knowledgeable, but don't hesitate to ask. You just don't know what might be available.
Right. Thank you, Alan and Tom. I think now I'll just answer that quick question that also came in about the material. So just to let all the attendees know, at the end of the webinar, you will receive an email with a survey to complete for the attendees. And I will also share a link in that to the presentation so that you'll have the copy of the presentation. We also have these, all the recordings of all webinars that the DMZ is hosting during COVID-19 available to public. So if you Google search DMZ COVID-19 free virtual workshop, you should be able to get on the page that has the recordings. We will upload the recording of this webinar shortly as well. So just to answer that question, that you will have access to it. So right now, I would like to ask Ali Tayeb, the Manager of Partnerships at the DMZ, to just thank our speakers for today.
Hi, Sweeney, can you hear me?
Yes, we can hear you.
First of all, thank you, Alan, Luke, Tom. That was an amazing session. Definitely learned a lot of new pieces there. Great to hear that from you, Alan, that businesses are trying to do whatever possible to help the startups in this time of need. Again, want to thank Goodman's for their partnership. We've been working with them since 2017 through the Professional in Residence program. They benefit our community in general quite a bit, and the startups, and we're really glad that we can expand this relationship to the community at large. So thank you very much. I think it was a very rich discussion from the questions that came in, and Sweeney, there's some questions that actually came in over email. I'm sure that you'll probably look at them later. But just want to thank everyone once again for participating in the session, and do look out for more webinars that will be coming shortly from the DMZ.
Thanks, Ali, for joining us. I'm sure the attendees found the information shared today useful and timely as they seek to manage staff and maneuver unknown challenges. If any of you can think of a question later on, feel free to email me, and my email is on the screen, sweeney@ryerson.ca. If you know of a business founder who wasn't able to attend the webinar, please direct them to Google search DMZ COVID-19 free virtual workshop, and they will be able to see this recording and reach us with any questions. If you're a DMZ founder, whether current or alumni, you do have access to Goodman's and the Goodman's team and other professionals and residents at any time. So head on to the DMZ portal and book your one-on-one virtual meeting with our PIRs during their weekly office hours. Remember, you can also engage our PIRs at DMZ exclusive discounted fees. So when this webinar ends, please feel free to have a look in your inbox for the email with the survey. For the attendees, the email with the survey and the PowerPoint presentation slides. So thank you everyone for joining us this afternoon, and stay safe.